taxes in Switzerland are levied by the Swiss Confederation, the cantons and the municipalities. Legal framework. Fiscal sovereignty. Switzerland is a federal republic in which the sovereignty of the constituent states is limited by the enumerated powers delegated to the federal state through the federal constitution. Consequently, the original authority to levy taxes is vested in the individual cantons of Switzerland through the constitutions. Within the bounds of the authority delegated to them by cantonal law, the municipalities may also levy taxes. The extent of that authority varies from canton to canton, while the formal framework of the most important cantonal direct taxes has been harmonized through the 1990 Federal Tax Harmonization Law. The cantons remain free to set their tax rates or establish new taxes, except on tax objects already taxed under federal law. Since World War II, the federal constitution authorizes the Confederation to levy a number of taxes, the most significant of which are an income tax, a withholding tax, and a value-added tax. However, Switzerland is unique among modern sovereign states in that the authority to levy these taxes is limited in duration and extent. The Constitution imposes an upper limit on the federal tax rates and causes the federal authority to levy taxes to expire in 2020. A renewal of that authority requires a constitutional amendment, which must be approved in a popular referendum by both a majority of the popular vote and the cantons. If that renewal is not approved at the polls, the Confederation itself will conceivably dissolve for lack of funds. All attempts to remove this limitation by amending the Constitution to provide for a permanent federal authority to levy taxes have been rejected in Parliament, or no less than 5 times, by popular vote, most recently in 1991. Constitutional limits to taxation. The federal constitution imposes certain limits on taxation at the federal, cantonal and municipal levels. To begin with, it provides that no tax may be levied except where provided for by federal, cantonal or municipal statute, because statutes can at all levels be made subject to a popular referendum. Swiss tax rates are in practice set directly by the voters through instruments of direct democracy. The Constitution mandates that taxation must be general and equal in nature, and it must be proportionate to one's ability to pay. The Federal Supreme Court has interpreted this as prohibiting a regressive tax, although flat-rate taxes are held to be constitutional by tax law scholars. Moreover, double taxation by several cantons is constitutionally prohibited, as is a confiscatory rate of taxation. Direct taxes on natural persons. All people resident in Switzerland are liable for the taxation of the worldwide income and assets, except on the income and wealth from foreign business or real estate, or where tax treaties limit double taxation. For tax purposes, residence may also arise if a person stays in Switzerland for 30 days, or for 90 days if he or she does not work. Moreover, non-residents are also taxed on certain Swiss assets or on the income from certain Swiss sources, such as from real estate, permanent business establishments or pensions. The income and assets of spouses are pooled and taxed jointly, but at a lower rate to offset the effects of tax progression. Income tax. Either a progressive or proportional income tax is levied by the Confederation and by the cantons on the income of natural persons. The income tax is imposed as a payroll tax on foreign workers without a residence permit, and in the form of a withholding tax on certain transient persons, such as foreign musicians performing in Switzerland. Taxable income includes all funds accruing to a person from all all sources, in principle without deduction of losses or expenses, and including the rental value of a house lived in by its owner. However, capital gains on private property are tax-free, except where the cantons levy a tax on real estate capital gains. Certain expenses are also deductible. These include Social Security or pension fund payments, expenses related to the gain of income and alimonies. Gifts and inheritances are also exempt from the income tax, but are subject to separate cantonal taxes. Non-working foreigners resident in Switzerland may choose to pay a lump sum tax instead of the normal income tax. The tax, which is generally much lower than the normal income tax, is nominally levied on the taxpayer's living expenses, but in practice, it is common to use the quintuple of the rent paid by the taxpayer as a basis for the lump sum taxation. This option contributes to Switzerland's status as a tax haven, and has induced many wealthy foreigners to live in Switzerland. In 2011, the federal income tax varied from a bracket of 1% and 0.77% to the maximum rate of 11.5%. Individuals earning below 13,600 and couples earning below 27,000 Swiss francs were exempt. On cantonal level, tax rates varies heavily. Obwalden adopted a 1.8% flat tax on all personal income following a cantonal referendum in 2007. In most cantons, the rate is proportional, with a maximum rate of 6.5% in Bern, whereas in Zurich it was 13% and in Geneva 17.58%. 76%. Property tax. A proportional property tax of around 0.3 to 0.5% is levied by the cantons on the net worth of natural persons. The tax is levied on the value of all assets after the deduction of any debts. Corporate taxation. Switzerland has a classical corporate tax system in which a corporation and its owners or shareholders are taxed individually, causing economic double taxation. All legal persons are subject to the taxation of the profit and capital, with the exception of charitable organizations. Tax liability arises if either the legal seat of the effective management of a corporation is in Switzerland. To the extent non-resident companies have Swiss sources of income, such as business establishments or real estate, they are also liable for taxation. Conversely, as a unilateral measure to limit double taxation, profits from foreign business establishments or real estate are exempted from taxation. Profit tax. A proportional or progressive tax is levied by the Confederation and the cantons on corporate profits. The tax is based on the net profit as accounted for in the corporate income statement, as adjusted for tax purposes. For instance, expenditures that have no business reason, such as excessive depreciations, accruals or reserves, as well as disguised dividends, are taxed as profits. A number of provisions limit the double taxation of profits at the corporate level and contribute to Switzerland's tax haven status. To begin with, a participation exemption is granted to companies who hold 20% or more of the shares of other companies. The amount of tax due on the corresponding profit is reduced in proportion to the percentage of shares held. At the cantonal level, only a holding privilege applies to pure holding companies. They are exempt from the cantonal corporate profit tax. Moreover, cantonal law confers a domicile privilege on companies who are only administered in Switzerland, but whose business is conducted abroad, including shell corporations. The cantons tax only around 10% of the worldwide profits of such companies. Capital tax. A proportional tax is levied by the cantons on the eigenkapital of companies. Thinly capitalized companies are taxed, moreover, on the liabilities that function as equity. This also means that debts paid on such liabilities cannot be deducted for purposes of the profit tax, and are subject to the federal withholding tax. Other federal taxes. Value-added tax. The value-added tax is one of the Confederation's principal sources of funding. It is levied at a rate of 8% on most commercial exchanges of goods and services. Certain exchanges, including those of foodstuffs, drugs, books and newspapers, are subject to a reduced VAT of 2.5%. Yet other exchanges, including those of medical, educational and cultural services, are tax-exempt, as are goods delivered and services provided abroad. The party providing the service or delivering the goods is liable for the payment of the VAT, but the tax is usually passed on to the customer as part of the price. Federal withholding tax. The federal withholding tax is levied at a rate of 35% on certain forms of income, most notably dividend payments, interest on bank loans and bonds, liquidation proceeds, lottery prizes and payments by life insurances and private pension funds. The debtor of such payments is liable for the payment of the tax. They must pay the creditor only the net amount. With respect to creditors resident in Switzerland, the withholding tax is only a means of securing the payment of the income or profit tax, from which the creditor may then deduct the amount already withheld, or request its refund. The same applies to foreign creditors to the extent that a tax treaty provides for it. Other foreign creditors are not eligible for a refund. With respect to them, the withholding tax is a genuine tax. Stamp duties. Stamp duties are a group of federal taxes levied on certain commercial transactions. The name is an anachronism and dates back to the time when such taxes were administered with physical stamps. The issue tax is levied on the issue of certain securities such as shares and bonds. Exceptions are made, inter alia, for securities issued in the course of a commercial reorganization, and the first million CHF of funds raised are in effect exempt from taxation. The tax amounts to 1% of the funds raised and is payable by the issuer. The trade in shell companies is also subject to the issue tax. The transfer tax is levied on the trade in certain securities by certain qualified traders. The tax amounts to 0.15 or 0.3% depending on whether Swiss or foreign securities are traded. Finally, an insurance premiums tax of 5 or 2.5% is levied on certain insurance premiums, border duties and miscellaneous federal taxes. The Confederation is constitutionally empowered to levy tariffs, which were its principal sources of funding up until World War I, but are now more important as an instrument of trade policy. Additional federal taxes of lesser economic importance include taxes on the importation or manufacture of spirits, beer, tobacco, automobiles and mineral oil, as well as on gambling establishments. Citizens exempt from military service are required to pay a tax in compensation. Other cantonal taxes. In addition to the taxes mentioned above, the cantons are free to introduce others. Several cantons levy an inheritance tax and a gift tax, although there is a trend towards abolishing those. Moreover, the cantons are required by federal law to levy a tax on the profit from the sale of real estate. Most also levy a tax on the value of the property sold so as to discourage speculation in real estate. Taxes are also frequently levied on the ownership of dogs and motor vehicles, on lotteries, on the sale of tickets to public entertainments, or on overnight stays in certain tourist destinations. tax-related criminal law. Depending on the nature of the tax at issue, criminal offences related to the non-payment of taxes are regulated in substantially different ways by cantonal and federal statutes. This section will therefore discuss only the outlines of the harmonized rules governing tax evasion and tax fraud with respect to the federal and cantonal income, profit, property and capital taxes. It is a criminal offense under cantonal and federal law to willfully cause one's taxes to be incompletely assessed. The statutes distinguish, however, between tax evasion and tax fraud. Tax evasion is the act of causing a tax to be falsely assessed, such as through the failure to report taxable income. It is classed as a misdemeanor and is punishable by a fine of 33% to 300% of the amount of tax evaded. Tax fraud, on the other hand, occurs if a tax evasion is committed by using false documents for deceptive purposes. It is classed as a crime and is punishable by additional imprisonment of up to 3 years or an additional fine of up to 30,000 Swiss francs. This distinction is of particular importance with respect to the level of international judicial assistance afforded by Swiss authorities to foreign states that prosecute their own citizens for tax evasions committed in Switzerland, such as by depositing undeclared income with a Swiss bank. Up until recently, Swiss law prohibited all support to foreign jurisdictions for the prosecution of fiscal offences, except to the U.S. under the terms of a 1973 agreement. Since 1983, enforcement assistance is provided for the prosecution of fiscal crimes but not for the prosecution of fiscal misdemeanors. Under pressure from the G20 and the OECD, the Swiss government announced in March 2009 that it will abolish the distinction between tax fraud and tax evasion in dealings with foreign clients. The Swiss authorities will from now on also provide judicial assistance in the event of tax evasion by a foreign client. The distinction remains valid for domestic clients. Tax rates and statistics. In 2002, some 134 billion Swiss francs in taxes were levied in Switzerland, of which roughly one-third was levied by the Confederation, the cantons and the municipalities, respectively. The overall fiscal rate was 38.5% of GDP in 2002. The effective individual tax rate is subject to considerable variation depending on the canton and municipality of residence. For instance, companies subject to ordinary taxation paid between 13 and 25% of income tax in 2006, and the maximum individual tax rates in major cities ranged between 12.3% in the canton of Zug and 32.3% in the canton of Jura. Bibliography. Tax law. Raymond, Tony. Repetitorium zum Steuerrecht. Bern. Haupt. ISBN 978-3258-07124-4. Locker, Peter. Blumenstein, Ernst. System des Schweizerischen Steuerrechts. Zurich. Schulthess. ISBN 3-7255-43429. Mausley, Alan Spatch, Peter. Oertli, Matthias. Das Schweizerische Steuerrecht, ein Grundriss mit Beispielen. Bern. Kosmos. ISBN 3-85621-171-3. Others. Linda, Wolf. Schweizerische Demokratie, Institutionen, Prosis, Perspektiven. Bern. Haupt. ISBN 978-3258-06842-8.